Do you know someone who is currently in a care home or hospital and objects to being there? Do they lack the capacity to make a decision about where they should be staying themselves? In this video, I will set out how you can challenge someone's deprivation of liberty under Standard Authorisation in the Court of Protection. My name is Olivia Allen and I work in the Court of Protection Department at GN Law. A Standard Authorisation is a lawful way to deprive someone of their liberty in order to care for them in a hospital or care home where they do not have the capacity to make that decision themselves. I've addressed this in the first video of the series. However, where a standard authorisation is in place, one key safeguard is the right to challenge it in the Court of Protection. So, when would you want to bring a challenge? Firstly, a family member may not be happy with where someone is staying. For example, someone has been put into a care home, but the family in fact believe it would be in their best interest to be cared for at home. Secondly, the person who lacks capacity themselves may show a consistent wish to leave the place that they're in. Though remember, their objection might not always be verbal, but could in fact be in their actions, for example, by trying to escape. So, how can a challenge be brought? In order to challenge a standard authorisation, an application must be brought under Section 21A of the Mental Capacity Act 2005. And finally, who can bring the challenge? In general, there are three people that can. Firstly, an application can be made by the person that lacks capacity themselves. Secondly, and more commonly, this can be done on their behalf by their relevant person's representative, their RPR. This is often a friend or a family member, but could also be a specialist advocate. And thirdly, the application can be brought by the relevant local authority, asking the court to review the standard authorisation. Now, if it is clear that a challenge does need to be brought, for example, because the person is consistently objecting, and if there are no friends or family members able or willing to make the challenge, and equally their RPR is not doing anything, then the responsibility will fall on the local authority. You should now have an understanding of how you can challenge someone's standard authorisation in the Court of Protection. Though finally, please note that the Deprivation of Liberty Safeguard Scheme will be changing in October 2020, and we have other videos on the new scheme which you may find helpful. If you need help and advice on this or any other Court of Protection matter, call me today on 0208 492 2290. And if you found this video helpful, please share it.